We will give you a moment to find your seat before it becomes even darker. We know we're a little behind schedule. We think we might catch up some in the second half. And as you noticed, the last ingredient to our program is a panel discussion. And as you know, panels are infinitely variable. We can stop them right after they start if we have to, so everything will be okay. The next part after the trial that has been so well described by General McDonough were the appeals. And there were multiple appeals, that's why it's plural. And to bring you the appeals, the man that handled much of that, if not all of that, by the State Attorney General's office, former Assistant Attorney General, former Assistant District Attorney General, and now lawyer in private practice, David Rabin.
Good afternoon. Appeals in criminal cases have their own twists and turns. A sensational jury trial lasting weeks can be reversed in an instant by the stroke of a pen wielded by an appellate judge. I'm going to talk a little bit about the appeals and a little bit about the law. Monica asked me to inject a little law into my presentation so that you could get CLE credits. One of the speakers mentioned the fact that an accessory after the fact could not be prosecuted if he or she was a blood relative of one of the defendants. And that's true back then. It's the so-called Jesse James law, where they didn't want to prosecute Ma for hiding out Jesse James. And so that was an exception, which we changed in 1989. Now, what follows is a tortured path of the appeals for both John Brown and Marvin Douglas Brown. In working on this segment, I discovered a vast number of people who were involved in the case whom I knew in other roles. For example, Tom Thurman was a court officer in Judge Cornelius's court during the trial. Years later, he was an assistant district attorney involved in post-conviction petitions filed by one of the Browns. Other people gave me some perspective in the case, which made it very real. Deb Faulkner is former deputy chief of police here in Nashville. She's now the chief of police for the Franklin Police Department. When Deb was 22, she was an usherette at the Opry when Stringbean performed there. I interviewed Deb. Deb said she recalls that on November the 10th, 1973, she was talking to Stringbean as he came out the backstage door about 10:30 after his last performance. He was waiting for Estelle to pull up and drive them home in their green Cadillac. She recalled that he had on his overalls and was carrying his costume. In his overalls, as we now know, he had some $3,000 cash. She put him in the car, and Estelle drove away, up Fifth, toward church, to go home where the killers were waiting for them. And the most chilling part of the case is the killers were listening to the Opry on the radio and hearing Stringbean play and waiting for him to come home. As far as we know, other than the killers, young Deb Faulkner was the last person to see Stringbean and Estelle alive. It is, of course, a myth that the jury convicted the killers exactly a year after the homicide. The conviction occurred on November 2nd, 1974. It was a Saturday. Back then, we had jury sentencing, and the jurors imposed 99 years on both defendants for each murder. The jury recommended concurrent sentences, and the judge ran the sentences consecutively, one after the other. And the Browns were sent to the state penitentiary that same day, and that's the court order sending them to the state prison that day. There were two defendants and two separate trials, and two separate appeals, which took very different tracks. As we will learn, Doug Brown waited some 7 years before he appealed his case. Joe Binkley Sr. represented Doug. I think to see what success John Brown might have in his appeal. In short, Joe Binkley Sr. was clever by waiting until John Brown ran the rapids before Joe Binkley put his toe in the water. Joe, as many of you know, was one of the finest trial lawyers in the city, best known for defending many Belle-Meade widows charged with accidentally killing their husbands. That's true. When John Brown was convicted, I tried some cases against him. He was an amazing lawyer. When John Brown was convicted, his lawyer was Arnold Peebles. And Arnold Peebles vowed that there would be an appeal. Look at that face. That is Arnold Peebles, a force to be reckoned with. And he swore that there would be an appeal. John Brown's appeal began with skeleton motions for new trial filed by Arnold Peebles and co-counsel David Pack. Pack, as we know, was a former Attorney General for the state of Tennessee and was the man who gave me my job right out of law school to work in that office. There were long delays in getting the appeal perfected because the court reporter had garbled some of the transcriptions and much of the record had to be constructed. And the lawyers had their clients declared indigent, which meant that the court reporter wouldn't be paid her regular fee. And so she promptly left, and they had to reconstruct the record with a new court reporter. In any event, John Brown fires Arnold Peebles on the Ides of March of 1975. In his stead, John Brown hires Bo Edwards. Bo Edwards is an excellent lawyer. At the time, he was 31. Like many of us, Bo had been an assistant district attorney in Nashville. He later went on to become president of the Nashville National Association of Criminal Defense Lawyers. He died of kidney disease in 2004. Bo took a very aggressive position at the hearing on the motion for new trial. He put on considerable proof that Arnold Peebles was addicted to cocaine and was taking drugs throughout the trial. And you'll hear about that next. Normally, ineffective assistance of counsel is only addressed in post-conviction proceedings or habeas corpus. To my knowledge, this was the first time ineffective assistance of counsel was raised on direct appeal, where there was something of a full record regarding the alleged incompetence of the trial lawyer. And so after the motion for new trial was denied, the record made its way to the Court of Criminal Appeals on January 14, 1977. Bo filed his brief on March 29, 1977, and attached was an appendix containing 65 claims of error alleging incompetence of Arnold Peebles. The list of sins was reminiscent of Thomas Jefferson's grievances against the King George in the Declaration of Independence. The State Attorney General's office is charged with representing the government in all appeals. I had been in that office a few years and enjoyed some success. Tom Schreiber asked State Attorney General Brooks McLemore if I could do the appeal for the state. I was very flattered at the assignment. I was 27 years old. I worked exclusively on the case for a month, and I can assure you Hal McDonald was one of the lawyers for the state. I read the record, prepared the brief, and filed it on April 21st, and we argued the case in May 1977. The appeal was challenging. Apart from the problems regarding ineffective assistance of counsel, we had 3 brand new decisions by the Supreme Court which touched directly on the issues raised by Bo Edwards. The question was, for these issues, these new decisions, would they apply retroactively, any one of which could have reversed the case? The first issue, of course, dealt with the constitutional standard of ineffective assistance of counsel. At the time of the jury trial, the ineffective assistance could only be established by showing that the trial was a farce or mockery, and the new standard was whether the lawyer significantly departed from acceptable norms and if the client were prejudiced. Fortunately, I was able to convince the court that Peebles rendered effective assistance of counsel. And the next issue dealt with consecutive sentencing. The Supreme Court had come out with new rules regarding that. Again, I was able to convince the court there were enough reasons for Judge Cornelius to have run the sentences consecutively. Not that it mattered much, because under the law at the time, they would still be eligible for parole in 30 years, even though the 2 sentences were running wild, which Torrey Johnson will discuss later. Lastly, if that wasn't enough, the Supreme Court changed the standard for insanity. Arnold Peebles raised a very vigorous insanity defense for his client. He even convinced Judge Cornelius to bifurcate the trial and have one trial on insanity and another on guilt or innocence, virtually unprecedented. One jury considered the insanity, and then a later jury considered the guilt or innocence. Shriver put on 9 expert witnesses, all of whom testified that Brown was sane. I won that issue and convinced the court that the insanity rule should not apply retroactively in that case. We got down to oral argument. I hit on the idea of asking Tom Shriver himself to sit next to me at counsel table in the Court of Criminal Appeals. No district attorney had ever been asked to participate at that level. I argued the case, of course, but Tom Shriver was sitting there right next to me to help me with any issues that came up. It was during the preparation for that oral argument and preparation for the appeal that I got to know Tom Shriver very well. The media was there in force. It was high drama, to say the least. Bo Edwards was aggressive and complained bitterly about Arnold Peebles' cocaine use. As I recall, I was trying to address issues regarding the retroactivity of 3 Supreme Court decisions. While we were waiting for the court to rule, Tom Shriver called me up and asked me to come down and work in his office, which I declined, but only for a day. My wife convinced me that this was a great career move, and I went over to Tom's office in October of 1977, where I stayed for some 7 years. Meanwhile, the Court of Criminal Appeals affirmed the conviction on February 1st, 1978. Bo appealed to the Supreme Court of Tennessee, which ruled that Judge Cornelius had not allowed in enough evidence regarding Peebles' incompetence, and said, we want to have more evidence, more witnesses need to testify. So there was another evidentiary hearing in front of Judge Cornelius, which you'll hear about. It went back up to the Court of Criminal Appeals, and the Supreme Court ultimately affirming the convictions. And then John Brown filed a petition for habeas corpus in federal court. Now, those of you who don't do criminal work, you can go from state court to federal court in a rare proceeding called habeas corpus, and letting the federal judge perhaps reverse the conviction. The online materials that we provide you contain the transcript of the amazing hearing in front of none other than Judge L. Clore Morton. Amazing man and in force. May the 5th, 1982. The witnesses included Harlan Dotson III and Arnold Peebles himself. At the end of the hearing, Judge Morton said that he himself had never been in a courtroom with whiskey on his breath or anything like that, but he said there was a lawyer in Knoxville who was the best criminal lawyer in the city, and he couldn't get up to steam until he had a couple of drinks. Morton continued, and I quote, after that Knoxville lawyer had about a pint, he could put on the dangest defense you ever saw in your life. I mean, literally. He was letter perfect about a half a pint of whiskey. But until he had a half a pint of whiskey, he just couldn't cut the mustard. He could do a perfect job. I've seen him pull out more cases than you could shake a stick at. My Knoxville attorney friends, I've asked them, I said, who could this be? And they said, well, it's the great Ray Cate, the famous lawyer from over there. Morton then said he'd read the record and issue a ruling, and there's Judge Morton drinking a Coke. Judge Morton upheld the conviction on July 28th, finding that John Brown received effective assistance of counsel. As far as I know, that ended John Brown's appeals, and as Torrey Johnson will later address, Brown was paroled in 2014. Meanwhile, Joe Binkley Sr. bided his time for his client, Marvin Doug Brown. Some 7 years after the trial, Binkley eventually had a hearing on his motion for new trial. It was denied, and the matter went up to the Court of Appeals. The issue there concerned Marvin Brown's allegation that his rights were violated by the bizarre behavior of his co-defendant counsel, Arnold Peebles. He argued that his rights were repeatedly violated because of Arnold's bizarre behavior. Because John Brown's appeals were unsuccessful, Marvin fared no better. His appeal was denied on September 28, 1982. The Tennessee Supreme Court denied review in 1983. He then filed a post-conviction petition alleging that Joe Binkley was ineffective. Judge Mark Fishburne was appointed to, now Judge Fishburne was appointed to represent Marvin Brown. The issue concerned Joe Binkley's failure to ask for a severance or a separate trial. This was based on the argument that Brown had confessed, and the Court of Appeals held there was no constitutional violation because the confession did not implicate Marvin Brown. And as you recall, John Brown said that he had passed out, and upon awakening, Marvin Brown told John that he, John, had killed 2 people. Next, Marvin Brown complained that Mr. Binkley didn't question all the witnesses prior to trial and was unprepared. The court concluded even if Joe Binkley had had 20 years to prepare, the trial would not have been any different. Given the overwhelming weight of the evidence against Marvin Brown, mostly arising from his own confession, to the news media there was no probability that any change in strategy would have made any difference. The Tennessee Supreme Court denied review on November 30, 1992. Marvin Brown died of natural causes on January 8, 2003 at Brushy Mountain Prison in Petros, Tennessee. He's buried in the prison cemetery. His appeals are now in the hands of the Almighty. Given the benefit of 40 years of hindsight, I wonder if the case would have proceeded differently if tried today. Remember that Peebles and Binkley were lions of the bar. They truly were the very best lawyers in the city and the most aggressive, very good lawyers. The rules were different back then. In my view, given the enormous publicity surrounding the case, I think a severance between Marvin and John Brown probably would have been inevitable under today's standards. That, of course, begs the question of which one would have been tried first. Tom Shriver and Hal McDonough were extremely aggressive and very effective in putting on the state's case. This was truly a battle of titans. They countered all the defense arguments. It's rare that the district attorney himself tries a case. But Tom Shriver knew that this was important and participated in the investigation, the trial, and as we know, the appeal with me. I don't think lawyers today would have their clients admit to participation in a murder scheme, but again, if guilt is cast elsewhere, it might be effective. That said, having re-reviewed the case, I think it inevitable that both John Brown and Marvin Brown would have been convicted. Running through the appellate opinions, it's obvious that the overwhelming nature of the proof prevented any reversal at any level, notwithstanding the possible retroactivity of 3 opinions. I acquired the entire record from the Court of Criminal Appeals. It was scanned. It's online, and you all can have available to that. Tommy Jacobs sent us the crime scene photographs, many of which you've seen have been scanned up here on the board. And now my good friend and colleague, Bill Cohen, will address more about Arnold Peebles and ineffective assistance to counsel. Thank you.
David has given you a concise history of the appeals and the other post-conviction proceedings in this case. Excuse me. I would like to talk more about the factual basis underlying the claim that Arnold Peebles provided ineffective assistance of counsel to John Brown, and also talk about issues relating to impaired attorneys. In 1974, Arnold Peebles was 36 years old and enjoying his reputation as a top-flight criminal trial lawyer. Peebles' formative years as a litigator under Tom Shriver included prosecution of many cases. An urban legend about Peebles was that during the days of jury sentencing, he inflamed one jury panel to the extent it sentenced one unfortunate soul to 15 years in jail for stealing one Butterball turkey. True or not, the story reflected Arnold Peebles' reputation. Following John Brown's conviction, Joyce Wilharm, who was his first cousin, and the family's primary contact with Arnold Peebles, began hearing rumors of Peebles' hospitalization for drug-related issues. This news was consistent with bizarre behavior Ms. Wilharm and John Brown's father claimed to have seen prior to and during the trial. As you heard, after the trial, Peebles was fired, Bo Edwards was substituted as counsel, and a supplemental motion for a new trial asserting ineffective assistance of counsel was filed. During the hearing on that motion, Bo Edwards introduced evidence through Wilhelm, Brown's father, and others that, 1, Peoples would make appointments and then not appear. 2, there were times when Peoples could not be contacted by Wilhelm or Brown's father. 3, Wilhelm and Brown's father would be called by members of Peoples' office who were looking for him. 4, Peoples would frequently state, "I'm going to walk him." This feeling of euphoria can be consistent with the use of cocaine. However, Peoples was an extremely confident lawyer and could have really believed that he was going to walk his client, or he could have been saying that to ease the fears of his family. 5, at times Peoples would lose his train of thought and begin to ramble about totally unrelated subjects. 6, Peoples was twice observed with white powder on his nose. 7, Peoples was observed on a number of occasions putting a finger, sometimes containing a liquid like Coca-Cola, up his nose. Such actions can be consistent with the use of cocaine. 8, Peoples' speech was often slurred, his nose running, his eyes red, and during meetings he would frequently step out of the room for brief, unexplained reasons. 9, on the Friday before the beginning of trial, Peoples did not appear for a meeting he had scheduled. An unidentified female told Ms. Wilhelm that Peoples was in a stupor and could not drive. 10, on the Wednesday evening of trial, Peoples had to be held upright by 2 people who assisted him in walking to his office. He had been late to court that day because of some unexplained problem. The director of Vanderbilt's Drug Treatment and Rehabilitation Center testified by deposition to the effects and symptoms of cocaine use. His description was consistent with that reported by some of the witnesses. During the hearing after the remand by the Tennessee Supreme Court for further evidence on the issue of Arnold Peoples' mental and physical condition at the time of the trial, evidence concerning Peoples' 4 admissions to Parthenon Pavilion, a psychiatric facility in Nashville, from August 1973 through June of 1975, revealed: 1, Peoples had first been admitted to Vanderbilt Hospital in 1970 for acute depression. His admission to Parthenon in August 1973 was for acute depression and alcoholism. At that time, he had been seeing a psychiatrist for 6 months. He was confused and unable to make decisions. 2, during an 11-day admission in January of 1975, Peoples was diagnosed as manic depressive. On admission, he was acutely depressed and suicidal. 3, a 1-day admission in February 1975 noted that Peoples was manic depressive with a depressive reaction. 4, on June 8, 1975, Peoples was again admitted, this time for 26 days. Upon admission, it was noted he was manic depressive, currently in a manic phase. It was during this admission that Peoples surrendered his law license. In rendering his decision following the remand from the Tennessee Supreme Court and the additional evidentiary hearing he held, Judge Cornelius pointedly stated that he reviewed the decision of the Tennessee Supreme Court in Baxter v. Rose, which dealt with competency of counsel, and the authorities it cited. Having done so, it was clear that Judge Cornelius saw no need to get into the implications of Peoples' medical and substance abuse issues, particularly since there was no competent proof that Peoples had been taking drugs at any time relevant to the trial. Instead, he held that the trial record, quote, reflected a most aggressive defense counsel assisted by a very able and aggressive co-counsel whose credentials were well known by all the courts in the state. He also found that, quote, defense counsel had demonstrated an extreme sensitivity to the issues and unquestionably put the prosecution to its proof and pressed relentlessly the question of reasonable doubt. In the end, Judge Cornelius concluded that, quote, while the record reflected a sad situation, there had been no violation of the defendant's right to the effective assistance of counsel. When read together with earlier testimony, portions of the record cited by the Court of Criminal Appeals in its May 1981 opinion affirming Judge Cornelius' decision provide an interesting historical footnote. By January of 1975, Eddie Sisk had added his name to the firm of Pack and Peoples. James Price, who had previously worked in the district attorney's office under Tom Shriver, had then joined the firm as an associate. When Price discovered some white powder in a humidor on Peoples' desk around the time of Peoples' January 1975 hospital admission, the fledgling firm promptly dissolved, and Sisk went to the governor's office. The section of the Board of Professional Responsibilities website dealing with attorney discipline reflects that when Peoples surrendered his law license in June of 1975, among the charges pending against him was a claim that he had discussed with one of his clients a payment to the governor's legal counsel to obtain his client's release. Eddie Sisk was the legal counsel at that time and later pled guilty to federal charges relating to his taking money to secure pardons and paroles. At the hearing in the federal habeas corpus case before Judge Morton that David talked about, Arnold Peoples testified that he used cocaine during the time of John Brown's trial. Judge Morton was frankly not overly impressed with this testimony and said it sounded like Peoples was acting as an advocate and still trying to, quote, get his boy off. In his opinion denying the petition, Judge Morton said he was willing to assume that Peoples had used cocaine during the trial. However, he did not see that in and of itself that was a determinative factor. Rather, he said the standard to be met was whether, quote, counsel was reasonably likely to render and rendering effective assistance, close quote, of counsel under the Sixth Circuit case of Beasley versus United States. In Judge Morton's opinion, neither the testimony at the hearing nor the state record supported the conclusion that Peoples failed to, quote, perform at least as well as a lawyer with ordinary training and skill in the criminal law, close quote, as required by Beasley. Moreover, Judge Morton noted that David Pack had played an important role in the trial in questioning witnesses and assisting Peoples, and that Pack and Peoples had discussed trial strategy and concurred in the strategy that was pursued. Judge Morton said that for him to find that John Brown was denied the effective assistance of counsel, quote, the court would necessarily be required to hold that David Pack was also incompetent, and that will not be done. Trying to establish a lawyer's ineffectiveness based solely upon medical records can be a fool's errand. Firstly, it may be extremely difficult today to obtain medical records without the lawyer's consent, given specific federal confidentiality statutes such as HIPAA. Secondly, a medical professional would have to opine as to the meaning and implications of the records, but could not opine about whether counsel was effective. And it may not make a difference anyway. The ultimate opinion concerning a lawyer's competence is a legal one, predicated in large part upon the expertise and experience of judges, especially a judge who participated in the trial and observed the lawyer's performance, as Judge Cornelius did here. Even a showing of actual ineffectiveness may not be sufficient in the face of other overwhelming evidence of guilt. In 1984, the United States Supreme Court in Strickland versus Washington formulated a two-pronged test to determine compliance with constitutional standards of effectiveness of counsel. Using an objective standard of reasonableness, quote, with scrutiny highly deferential to eliminate the distortions of hindsight, close quote, a decision must first be made whether counsel's representation was objectively deficient. Assuming such a showing is established, a second determination must then be made whether such performance prejudiced the outcome. Both prongs must be met, and it is permissible to start with the second prong if that will facilitate the analysis of the reviewing court. And as you learned from all of the previous presentations, the proof in this case was overwhelming. Arnold Peoples' law license was restored in 1981. In December 1988, he was disbarred following an earlier 4-day jury trial in April of that year, in which he was convicted of promising a client he could bribe a judge for $5,000. He died in August 2013 at age 75. Peoples probably did have mental and substance abuse issues around the time of John Brown's trial. Assuming he did these issues affect his representation of Brown in such a manner that Brown did not receive the effective assistance of counsel? Peoples pursued a course of defense that he and David Pack apparently thought best under the law at the time and the facts with which he was confronted as the attorney for a very guilty client. While we today would most probably not have defended the case in the same way as Peoples did, particularly in light of the ways in which Bruton and severance issues are now dealt with, he had a strategy he aggressively pursued and enjoyed some success with, such as in obtaining a separate trial on Brown's sanity prior to the original trial, which I've never heard of before, and obtaining a jury determination of concurrent sentences, which is remarkable because John Brown was the shooter. The fact that the strategy did not work does not in of itself render his representation ineffective. However, opinions on this issue have and will likely continue to differ. A brief coda. While each individual's genetic composition and psyche is unique, the outward travails that beset Arnold Peoples are not. A study conducted by the American Bar Association, published in 2016, surveyed 13,000 lawyers in 19 states. It showed that 21% of licensed employed lawyers qualify as problem drinkers. Of particular concern is the discovery that younger lawyers in their first 10 years of practice exhibited the highest rate of problem drinking. The survey also revealed that a significant number of lawyers struggle with mental health issues. 28% of respondents reported some level of depression. 19% suffered symptoms of anxiety, and 23% had concerns with stress. Imagine that. An earlier study by Johns Hopkins in 1990 found that lawyers are 3 times more likely to suffer from depression than the general population. Aside from the raw statistics, the real concern is the finding that impaired lawyers seldom seek help. However, real help is available through the programs of the Tennessee Lawyers Assistance Program, TLAP. The services of TLAP grew from a modest program started by your Nashville Bar Association in 1982 to a statewide program staffed by experienced trained professionals who assist lawyers in dealing with a wide range of substance abuse and mental health issues. By statute and Supreme Court rule, communications with TLAP are confidential and not shared with the Board of Professional Responsibility, although TLAP does work closely with the BPR as part of referred disciplinary sanctions. In confronting possible impairment issues, it is important to keep in mind Rule of Professional Conduct 8.3, which requires the reporting of professional misconduct. A confidential referral to TLAP does not relieve a lawyer of their obligations under 8.3. However, the rule deals in the past tense where, quote, another lawyer has committed a violation of the RPCs that raises a substantial question of honesty, trustworthiness, or fitness. Comment 3 to 8.3 also suggests that the application of the rule requires some judgment in complying. Prior to deciding how to proceed if you are faced with such a situation, it may well be helpful and advisable to contact one of the disciplinary counsels to talk through the situation with them. Thank you.
Excellent. I will say, 1980, he said 82 is when it started. I was on the board, the bar then. It was the year I was elected president of the Nashville Bar. And the attitude toward substance abuse problems that has taken place in the last 36 years is amazing. Back then, it was not at all unusual for lawyers and law firms to break out the whiskey at 5 o'clock. And many of them drove home in a situation where they would be considered guilty of DUI today. I think we've come a long way. Of course, we have a long way to go, but that's a very poignant point made by Mr. Cohen. Next, we move to the issue, I guess we don't move to, we remain on the issue of rehabilitation. And we go to rehabilitation not of an impaired lawyer, but of the defendant himself, and also the parole of that offender. And for that presentation, we have none other than Victor S. Torrey Johnson, who for many years was an assistant district attorney prosecuting cases in our criminal courts. He became district attorney succeeding Tom Shriver when Tom Shriver went on the bench, and now he is a professor at the Belmont Law School, teaching, among others, my son Charles. Here is Torrey Johnson.
Good afternoon. As you have heard from Hal McDonough's account of the trial, once the two Browns were convicted by the jury, they were immediately whisked to the Tennessee State Penitentiary that night. At the time, the penitentiary was the foreboding castle-like structure that is still standing on Centennial Boulevard in West Nashville. It was there that the two cousins began serving their consecutive 99-year sentences for the first-degree murders of Stringbean and Estelle Akeman, following one of Nashville's most infamous criminal trials. At the time of this trial, Tennessee required that the jury determine not only whether a defendant was guilty or not guilty, but also upon conviction to impose a sentence as provided for by the state legislature. It was up to the jury to fix a term of years as it saw fit, based only upon the evidence produced at trial and the arguments of the attorneys for both the state and the defense. It was not until 1989 that Tennessee completely revamped both its criminal code and its sentencing law to introduce a modern judge sentencing scheme that we still operate under today. While much has changed regarding sentencing and parole since the Browns were convicted, certain fundamental principles have remained the same. As we've learned, the two Browns were convicted of 2 counts each of first-degree murder, one for Stringbean and one for his wife. The jury sentenced them both to 99 years on each count and recommended that the sentences be served concurrently. However, this recommendation was rejected by the trial judge, and he ordered the sentences to run consecutively for a total of 198 years for each defendant. Then, as now, criminal sentences are divorced from time calculations as we are accustomed to them in our daily lives in the free world. In other words, in the criminal justice system, a year is not a year as we know it, which introduces all manner of confusion to the general public and the media. The reason for this confusion is the concept of parole. The term parole comes from the French and as early as the 17th century applied to prisoners of war who would be released from captivity based upon their promise to return home and not take up arms again. This form of release was used extensively during the Civil War by both the Union and Confederate armies, often dictated by necessity when it was too burdensome to be responsible for large numbers of captured prisoners. In the meantime, reformers began to experiment with giving prisoners sentenced for crimes an incentive to change their criminal behavior. These incentives took the form of sentence reductions for good behavior while incarcerated, and early but conditional release from prison. The former, now known as good time, and the latter, now known as parole, are integral parts of Tennessee's criminal justice system, and those of other states as well. The parole concept was formally adopted in the federal system in 1910. Sentencing philosophy also changed with the advent of indeterminate sentences, where a defendant was sentenced to a range of years, such as 6 to 10 years, with the actual release date to be determined by a parole board, based on its conclusion that the defendant had been rehabilitated. Thus, parole was an important part of a reform movement that focused on rehabilitating a defendant and rejected the prevailing philosophy at the time of retribution. Today in Tennessee, it is difficult to say with much certainty how much time an individual was served before becoming eligible to meet the parole board. The initial sentence is automatically reduced by a fixed percentage based on factors such as the nature of the crime committed and the defendant's prior criminal record. A defendant who is considered a standard offender must serve 30% of a sentence before becoming parole eligible. For example, if a defendant received a 10-year sentence, he cannot meet the parole board until he has served 3 calendar years, or 30%. Except that the 3-year date can be further reduced by monthly good time credits that can shorten the sentence even more to perhaps as little as 22%. Also, it is important to note that parole eligibility is not the same as being released on parole. Being eligible only gets you a hearing, nothing more. While the intricacies of the parole system have ebbed and flowed since 1973, the general effect is the same: a substantial reduction of the sentence from that which was imposed. Turning specifically to the case of the two Browns, even though they both had been sentenced to 198 years, they were deemed to be eligible for initial parole consideration in as little as 30 calendar years because of a legal interpretation that effectively nullified the difference between concurrent and consecutive sentences. A 1913 Tennessee statute said that any person with a sentence of more than 50 years would be eligible for parole after 30 years. With regard to the Browns, the Department of Corrections made them eligible in 30 years since their total sentence clearly exceeded the 50-year threshold, thereby ignoring the judge's directive that the two sentences were to be served consecutively. In essence, because of this legal interpretation, the Browns escaped the consequence of the trial judge's decision to specifically reject the jury's recommendation of concurrent sentences. A few short years later, in an unrelated case, the Tennessee Supreme Court ruled that the Department of Corrections' determination that there was no difference between concurrent and consecutive sentences was not only erroneous, but absurd. The court stated that if that were the law then, quote, all murders beyond the first would be on the house, and that society could protect itself only to the extent of the first murder. The decision was supposed to apply prospectively only and not affect those inmates like the Browns whose parole eligibility had been calculated under the old way prior to the court's decision. However, when the department got a new computer system in 1987, many prisoners found their dates recalculated and moved into the 21st century, including both of the Browns. Thanks to a court case in 1992, in which our own David Rabin played an important role, these parole dates were rolled back in accord with the Supreme Court's original intent. When that happened, the Browns were immediately eligible to meet the parole board because their 30-year minimum sentence had been whittled down to just under 20 years of actual service. So in July of 1993, both Browns went before the parole board for the first time in a hearing that was held at Riverbend Maximum Security Institution. Both sought immediate release on parole, but opposition to their release was swift and vocal, particularly from friends of the Akemans, the Grand Ole Opry. As district attorney, I was also opposed and attended this first hearing to express my opposition in person. John and Marvin were both 43 years old and had compiled exemplary institutional records over their nearly 2 decades behind bars. Media interest in this first application for parole was intense. John Brown gave an exclusive interview to the Tennessean newspaper immediately prior to the parole hearing, in which he claimed he was a changed man who only wanted a simple life upon release and an opportunity to help others. According to the interview, he had only a hazy and incomplete recollection of the crime because he was drunk that night, as he had been for most of the prior months because he was going through a divorce at the time. Prior to the murder, he described himself as being, quote, rowdy, but with only minor brushes with the law. But his life changed for the better when he was immediately transported to the state penitentiary after conviction in 1974. Brown said the shock of prison and 20 months in solitary confinement allowed him to take a hard look at himself. He said, "It gave me an opportunity to look at me, at the John Brown I had been avoiding for years. I had made a lot of realizations during that time. I realized, of course, that I was an alcoholic. 2 people had unnecessarily lost their lives. There's no way to make that up." While in prison, he joined Alcoholics Anonymous and pursued his education. While both Browns had the support of family and some prison officials, the parole board quickly denied their release because, according to parole board chairman Charles Traber, of the ruthlessness with which you committed these crimes. The board ruled that Marvin could reapply in 5 years, but John would have to wait 10 years because he was the admitted triggerman. Marvin reapplied in 1998 but was denied. In 2003, John returned and was denied again. Earlier that same year, Marvin Douglas Brown died of natural causes while still in custody. In 2008, after more than 34 years in custody, John once again appeared before the board. This time, he had letters of support from members of the community as well as a number of witnesses on his behalf, including his long-suffering wife. In addition to this support, Brown continued to work on self-improvement while in prison. His accomplishments were such that 2 board members present voted to recommend him for parole. One of these was Chairman Charles Traber, who had denied him 15 years before. When news accounts of the recent hearing indicated that Brown was likely to get parole if other members of the board concurred, public reaction was quick and negative. It turned out that through an administrative error, the district attorney's office had not been notified that Brown was up for parole. And although I had appeared and written in opposition in the past, my silence had been taken as acquiescence in 2008. I quickly disabused the board of that idea, and other concerned citizens circulated a petition in opposition and gathered more than 1,000 signatures in short order. As a result, the remaining board members voted to oppose his release, and he was denied once more. 3 years later, in 2011, John Brown was back again and nearing 40 years in custody. At 60 years old, he had come a long way from the drinking, drugging, rowdy 23-year-old who ambushed Stringbean and Estelle Akeman in their home. And his progress was not lost on board members. The Sunday Tennessean had a lengthy article about the upcoming parole hearing and had an interview with Brown's wife of nearly 40 years. Ironically, as a teenager, she had met Stringbean backstage at the Opry. He had been kind and funny and gladly gave her an autograph. Little did she know that 7 years later, her then boyfriend would be arrested, charged, and convicted for murdering Akeman and his wife. In the interview, she said she had married her husband shortly after the crime and before his arrest, and stood beside him all these years, in a marriage that had cost her friends, family members, and even jobs over the years. She pointed out that John had taken advantage of every opportunity to improve himself while in prison. She said, "Murder is murder. Dead is dead. You can't bring it back. I know it sounds harsh, but if they're letting other murderers out that have worse records than John, he deserves to be free." In the meantime, many of the most prominent opponents of parole from the Opry, like his longtime friend Grandpa Jones and the king of country music, Roy Acuff, had died. Nevertheless, country legend Bill Anderson started an email campaign, and Opry member Jan Howard appeared in opposition. The board noted that more than 450 people had written to express their opposition, and in the end, he was denied once more. Finally, in April of 2014, John Brown appeared again in front of the board, and it deferred final action until he underwent a psychological evaluation on his propensity for violence. The board reset his hearing until October of that same year. Energized by the 2011 hearing, country music stars Bill Anderson, Jan Howard, Gene Shepard, and Mac Wiseman were vocal in their opposition. On October 15, 2014, the board reconvened to hear John Brown's latest plea for release. Brown was now 64 years old. He recounted on that day of the crime, he was sitting around with family members and someone mentioned needing to make some money. John said his cousin, Charlie, had the idea to rob Stringbean and laid out the whole plan, somewhat different than what Charlie later said. John said, that he was armed with a .32 caliber pistol as they laid in wait until Stringbean came in from the Opry. From his testimony, he said, Mr. Akeman was shooting, and it just went haywire from that point. I mean, I panicked. I got scared. I shot Mr. Akeman, and then I shot Mrs. Akeman, and that's basically what happened at that crime. After his version of the facts, a board member pressed him on the fact that he had run down Mrs. Akeman as she had tried to flee and had shot her in the back of the head. John's only response was, yes, sir, it's my understanding. Yes, sir. After Brown's testimony, 4 witnesses testified on his behalf. Perhaps the most persuasive was a criminal justice professor from Western Kentucky University who had taught him for 4 years while in prison. She described him as a changed man and as the strongest victim advocate I have ever met in my life. 4 witnesses testified in opposition, led by Opry member Jan Howard, and I think we have a video clip of her.
They waited. They waited for them to come home. They knew what his schedule was. He didn't go out to dinner after the Opry. He always came home. They were waiting for him. And they shot String when he went in the house. And according to...
She went on to say it was premeditated. It wasn't accidental. He had ransacked their house, shot them execution style in the back of the head. They were merely praying for their lives. The board also noted it had received opposition from hundreds of other people. The board then allowed John Brown to make a last statement. He reiterated that he was a changed man who had made plenty of mistakes in the past, but he said, I am proud of what I have become today. I hold my head up and I'm not the person or that young punk I was back then. I'm different today. In the end, the board agreed to grant him parole, but it was not a unanimous decision. However, 4 members agreed that the admitted killer, who had never had a disciplinary write-up in more than 40 years in prison, was entitled to release. Reaction from the Opry family was hardly forgiving. Gene Shepard said, why should they turn him loose? He cold-bloodedly killed 2 friends of ours. I'm sure the Lord will forgive him. I don't think any of us will. Mac Wiseman didn't question Brown's contrition, but couldn't understand how a man with such a long sentence could be free. He said, it makes me question the legal system. In many ways, this case does indeed raise questions about the legal system, but not about its various shortcomings or faults, but rather about how painfully difficult it can be for all concerned. Some situations defy a clear answer or easy solution. 2 innocent victims were shot down at their own home by 2 young men careening through life fueled by alcohol, drugs, and greed. What made them commit the crime in the first place, and what made John Brown execute Estelle Akeman in cold blood are questions that elude an answer. A jury and a judge were appalled by the crime and meted out harsh sentences to the killers. But unlike so many other young men sent to prison for similar tragedies, John Brown set about making himself into a better person. After 4 decades in prison, one would hardly recognize the rowdy youth he once was. Remorseful and rehabilitated, he has tried to make amends for what he did to the Akemans and to society. Does that rebalance the scales of justice? Is all is forgiven as memories fade? Thank you.
6 years ago, when we were working on Baker versus Carr, we found out very close to the time of that program that there was a local connection to the plaintiff in the Baker case, a young lawyer named David Baker, who's an assisted federal public defender. And he brought to that program that day a copy of the decision given to him by his grandfather, who had been the original plaintiff in the landmark one man, one vote case. We got lucky again in this program. We found out just a few weeks ago that one of our local lawyers, Steve Gibson, was the son of Kirk Gibson, who had been not only the guitarist for Stringbean, but also one of Stringbean's close personal friends. So we thought that in light of the last 2 presentations, we would lighten the mood a bit to give you a few minutes with Steve Gibson and a great friend of Stringbean Akeman.
I suppose my credential to be before you today is that I have a cell phone with a number that was on the wall of Stringbean's cabin in his own handwriting the night of November 10th, 1973, above his landline wall-mounted telephone. And that's because my father, Kurt Gibson, had gone to work for him that spring. And in fact, he invited our family out as their guest twice during the last 6 months of their lives. In May of 1973, we went out to visit them because they were wanting us to move next door. They were wanting our family to move into the big farmhouse that had been vacated by Grandpa Jones. And I remember driving up, and Stringbean was wearing a hard turtle shell hat, shelling string beans. His wife, Estelle, and that's how a lot of country people pronounce it, talked to my mother and told her it was a safe place to live. She said, I think we could leave a bucket of money on the front porch and go on tour all summer, come back, and it would still be here. And they showed me what would have been my room in the house next door to them. But I balked, and I told my parents after that, I want to play baseball this summer, and that's too far out. And so my dad toured with Stringbean that summer. They played college campuses and just tore it up. They played to one young audience, and my father said that Stringbean turned to him after a song and said, he who plays the 5 rules the world. But they also played another college where they got more of a highbrow audience who might not have known quite what they were in for. And they didn't respond. And Stringbean told my dad after the show, Chief, I believe they took me serious. Well, in August of 1973, we went back a second time. And Stringbean was ready to try to persuade me to move out there. And so we sat on his front porch, the little red cabin that you've seen, 2 chairs, and he told me about his baseball career. And he told me, he said, I used to play for a semi-pro team, I used to play for Bill Monroe's barnstorming team, and I was the catcher. Said, one time I was catching, and this fool tried to steal second base on me. Said, I didn't even get up off my knees. Said, I threw the ball, went through the pitcher's legs, and hit second base, and he was out by a mile. And I knew I was about that far away from a deadpan comedian when he said that. But, of course, it was just about 3 months later that he was dead. And I well remember the Sunday morning which would have been November the 11th, that we received a phone call. I was dressed for church. My father answered the phone in the hallway, listened, hung it up, and turned to my mother and said, "Mom, last night somebody broke in and murdered String and Estelle." And she broke into tears. And so I'll never forget those events. And I've often thought about what might have been. But that last Opry show, Stringbean sang Hot Corn, Cold Corn. My dad, Kurt Gibson, sang harmony with him using this guitar. And then after the performance, he sang as his last song ever at the Ryman, as a rehearsal, another song. Because their harmony singing had gone over so well, he picked another song that they could sing harmony on. Lord, I'm coming home. And so I want to share with those of you who did not study hot, cold corn, cold corn in law school, the words of this Stringbean composition and a medley of the choruses of these two songs. Hot corn, cold corn, bring along your demijohns. Hot corn, cold corn, bring along your demijohns. Hot corn, cold corn, bring along your demijohns. Farewell, Uncle Bill, see you in the morning. Yes, sir. Then the song he sang before they left to meet their fate. Coming home, coming home. Never more to roam. Open wide thine arms of love. Lord, I'm coming home.
I don't know about you, but I could have had a little more of that. Steve, thank you so much. That really does add a personal touch to a program like this. We have an audible. That was a great audible. This one is more in the nature of a change. Our panel, and if the panel members would make their way on up to the stage, we had a three-man panel, including the last man standing, who's not yet standing, Al McDonough. And, of course, Tori Johnson, who's just finished telling you about the parole situation. And we thought we were going to be able to have Tom Thurman, who was a court officer in Judge Cornelius's court in 1974 when this trial occurred, and later was the trial prosecutor of Arnold Peebles, convicting him of bribery. But Tom is down on his back and couldn't make it today, so the audible is David Rabin is going to sit in for Tom Thurman and be a part of our panel here. A lot of emotion is tied up in a case like this, really for both sides. I think the public emotion clearly is on the side of a victim in a case as horrible as this, but then as you learn more about what John Brown accomplished in prison and then finally made parole, I guess you have to have some degree of empathy with his situation as well. But before I get to those competing interests, the one that really stands out to me is the story of Arnold Peebles. I don't know about you, but as lawyers, we tend to identify more with lawyers than with country music stars and people like the Brown family. But when I came back and was in the driver's office and saw Judge C.C. Daughtry, then General Daughtry, down in Division 2, there you are, she was in the courtroom with Arnold Peebles, and they were trying some of the high-profile cases of our day back in the early 70s. I remember Denver Burleson was one of them, and then Tom liked to prosecute the pornography shops, and so y'all tried several of those, and Herb Rich frequently was on the other side of those. And I'll tell you what, if you want to, I mean, trial seminars are great, but if you want to see something, watch Herb Rich against Arnold Peebles in Judge Draper's court. Am I right? He was an outstanding lawyer and a great football player. But first thing I wanted to ask our distinguished panel, Hal, you're in the middle. Let's start with you. Some of us have said, we already said today, I think a couple of you have said that he was a great lawyer, but the truth of the matter was, Hal, wasn't he more a showman than a lawyer?
No, I don't think I agree with you. I think he was, he knew the law and he knew how to use it, but on top of that was he certainly had a large personality, and he could dominate the courtroom, but he was still a good lawyer, I thought.
Despite Sissy's best efforts, weren't a lot of his convictions reversed?
Well, some of them. I mean, the one that I was talking about was where a guy, his name is Hubert Fudd. That's another seminar probably. But they prosecuted him for a robbery of a dress store on Hillsborough. And my recollection is they introduced what would on federal rule be 404B material, like 4 other robberies. And that resulted in the jury imposing, I think, a 75-year sentence. And that got reversed because, I guess, of the overkill of too many other robberies that were introduced. But I always thought that in addition to his personality and the way he could command the courtroom, that Arnold was a good lawyer.
Okay, well, I certainly respect your opinion. I was in one of those pornography trials, sitting in the back, just lapping it up as a law student. And I remember one time he argued to the jury in the close of one of those pornography cases that the 2 clerks sitting at the defense table weren't going to be the ones to pay the fine, so just levy the maximum fine, and the mob up in Detroit will pay it. I'm pretty sure that one came back, didn't it, Judge?
I have no independent memory.
Okay. All right.
Since I didn't have to retry that one, I don't know.
Yeah, that's plausible denial from Judge Stokes.
I think that was the case we were talking about, that in his argument to make emphasize the point that Arnold slammed his hand on the desk, and later told Judge Daltrey, I think I broke my hand doing that.
Yeah, he did. He sure did. Yeah, Randall White told me about that. Okay, now let's see, Mr. Rabin, you're a substitute over there. You have no idea what I'm about to say or ask, and that I like it that way. Jody, can we cue up video number 6? And then once we see this, former General Rabin, now lawyer Rabin, I want to ask you a question about it, but first let's see what Sherman Nickens did with Mr. Holt.
Jack Holt was one of the strongest people I've ever seen, and he told us where that they'd shot a weapon. And we'd go out there, and he literally pulled a tree stump in 2, showing us where some slugs are, and we found them. Yeah. I kept going to the opera, kept asking, and Jerry Clower was a comic or something up there. I've heard of him. He went up there, and Akeman told me that Clower had he sold promo for a company that he gave Stringbean a chainsaw. So, and so I asked him about it. He said, I can't tell you about it. Bud Wonder was standing there at the opera. I said, let me tell you something, Mr. Clower. If you don't tell me here, you're going to tell me downtown. You're going to tell me why this, that, and other. So he finally told me. He gave string, and I got the serial number and everything. Okay. Well, then Jack Holt, we'll get back to Holt. Went out there, and he said, I threw him in the river. So I found out that he traded a weapon for a man in a grocery store up there he got one of them weapons, so I knew that was a lie. He said, throw it in the river. Whereabouts? Well, carry it to the river. Right there, 10 degrees, Ed. He says, right there. I said, fine. Take your clothes off. He said, what? I said, get naked. He said, you go in there and get me one of them weapons. He said, I'll freeze to death. We'll pronounce you dead. Get naked. He said, I got him hid. So we took him, that's how we found the weapon.
Now, this is 1974, probably early 74. What about it, Mr. Rabin? Is that intimidation of a witness? Is there any problem with that?
That's the way they did things back then. I remember it was one of the other detectives, Larry Flair, he found a witness who was supposedly dead and brought the witness to my office, and he said, here's the dead man, and do you want to hear about it? And the guy said, yeah. But Sherman would do stuff like this, and he would tell people to do these things, and then of course I'm amazed he would say that today, but that truly was sort of how that was. But as long as the person was the defendant, his Shriver's rule was don't tell me about these things.
Now, Hal, I think you told me privately that you thought Sherman didn't really like to testify that much, and could this be part of that?
Probably.
Because I'm convinced Sherman Nickens is an honest man, and if some defense lawyer had known to ask him about this, you know, it might have come out.
I don't think that Tom Shriver would do that.
No, we didn't have Brady versus Maryland back then either.
All right, Tori, I've got one for you. Jody, that's going to be number 8, and what you can be thinking about. I like spring things on these guys, don't you? I'm going to ask you, after Sherman does a little talking here, about pressure, political pressure and media pressure to solve the crime and get a conviction.
Well, what's outstanding, the news media come alive on this one. I mean, it was every morning. They came, they wanted to know something, and the mayor at the time told me, she said, you got to come up with something. You've got to come up with, you've got to do something. And one day I went in and Kathy said, y'all not find out anything. I said, we're going as fast as we can. He said, well, I'm gonna do this and reassign y'all. Fine with me. In a few minutes, General Shriver called me. He said, come over here. He said, Sherman, tell me. I said, well, you call Lieutenant Kathy because I'm on another assignment on something. He said, you're what? He said, no. So he called the mayor. In a few minutes, they called me back and said, hey, take these men and find out something. Because they was getting heat downtown.
Heat downtown. Tell us about that, General.
Well, you know, this would be a classic case that you have something like this, and of course back then this was a crime that just shocked Nashville, and you can imagine that Nashville was smaller, the police department was smaller, the government was smaller, and I'm sure the mayor took it pretty seriously back then, and there was a ripple effect in the police department. But you know, again, it also focused their attention to commit the resources they needed to, because as you described in the investigation, you know, they had people under surveillance. They did a lot, but partly because somebody had lit a fire.
Now, of course, you were with us last year when we talked about the Trimble case. The crime in the Trimble case happened just a few months after the trial of the Stringbean murder. And in that case, we talked about a rush to judgment and media pressure and so on and so forth. Any relationship?
Well, there's no question that an active media, you respond. I mean, that you're having to. If every time you walk out of the office, or you know, Sherman would go to the car or whatever, there's some reporter asking a question, you just, you know, it becomes top on your list. And what you hope is that it merely propels you to work hard on it, not to come up with some suspect just to answer a question. But there's certainly examples of that.
Yes.
Hal, you practice a lot in front of Judge Alan Cornelius. How long were you in that court?
I don't remember.
I bet he does.
That was an interesting dynamic because there was some type of tension between Judge Cornelius and Tom Schreiber.
Oh, yeah.
And I think it was one of those situations where it gone on so long nobody could remember what the reason for the feud was. But it would be, it would crop up periodically and Judge Cornelius would say something and I'd go back to Schreiber and tell him and he would blow up and say, don't kill the messenger, I'm just telling you what he said.
Let me tell you a possible answer to that question. In the summer of 1973, right after I passed the bar, Bobby Schwartz had a murder case that happened out at the penitentiary, one of those on the house deals. And he didn't want to try it because there was some witness problems, so he handed it over to Doug Thorson. Thorson knew I was anxious to get in the criminal court, so we went in there to try it, but we didn't have any witnesses. And Judge Cornelius refused to grant a continuance, so I was left to pick a jury while Doug Thorson went to see Judge Russell on the Court of Criminal Appeals and get a writ of certiorari and supersedious. How many of you have obtained one of those? See a show of hand. Came back, and at 3 in the afternoon, I'd allowed about 2 or 3 jurors to be selected, and Jimmy Shea comes in the back of the room and hands that order to Judge Cornelius and retires like he's running away from a firework. And he just went off. He went ballistic on the bench. The General Schreiber, he didn't give me credit because I was 2 months out of law school. He didn't even give Thorson credit. He said Schreiber had done the most despicable thing. He said, no telling what he said. But that may have been the start of that.
No, it predated that.
Do you think? So we were just adding fuel to the fire.
Yeah. The story I always heard that Schreiber's mother and Cornelius' mother were friends somehow, and they never could understand why they're so different. I don't know if that's true or not. That's what I always heard.
All right. Now we've heard a little bit about Larry Brenton and the interviews, and I believe Hal has said that Joe Binkley, one of the most effective criminal trial lawyers in the history of Nashville, would occasionally go to the newspaper to get his man's story out in a way that he wouldn't be subject to cross-examination. Well, there was also gamesmanship on the part of the newspapers.
Reporter Larry Brenton got the interview of a lifetime.
I interviewed Douglas Brown, and he confessed everything about the murder to me. How it happened, why it happened, what time it happened, what led up to it, everything that could be said.
Not only did Brenton get a murder confession, he learned where the Browns had hidden some of the loot.
After the killing, they took his satchel. He had a little plastic satchel, like a gym bag, and they took it into Robertson County and threw it off in a little snake-infested pond. And so he told me all about how to get there and where it was.
Brenton, who worked for the afternoon paper, called Detective Sherman Nickens to meet him at the Snaky Lake to recover the stolen loot. He sent his photographer into the murky water, and they found the evidence. But the reporter would not turn it in until the deadline of the Nashville's morning paper had passed. Brenton wanted the scoop.
I couldn't run a story then because I was past my newspaper's deadline. And if I was to turn that stuff into the police, it'd be in the morning paper. And so I just had to hold on to it. Get past the Tennessee's deadline and give it to them.
But the bizarre story wasn't over yet. Following a tip from the other Brown, John, police divers suddenly showed up to search the pond for the evidence Brenton had already recovered. Brenton and Nickens watched for hours as divers plunged into the turbid water looking for the evidence Brenton had in the trunk of his car. It was a scene straight out of a skit from Hee Haw.
I went to the pond and I stayed with them for 6 hours while they dove for the bag that I had in the back trunk of my car. But I couldn't give it to them. I couldn't tell them I had it. So they finally quit. And they left and I left, and the next morning after the Tennessee's deadline, I turned the bag over to the police department If you look at the Nashville Banner that day, we've got the story everywhere. The confession, the story, pictures, everything. Just competition. Just competition.
It doesn't get any better than that, but the picture of the man in the water bringing the bag out of the water, that's Jack Gunner, who was the photographer for the banner, who was there to take the picture. And the reason that Sherman Nickens did not go in the water because it was full of snakes, and he said, I'm not going in there. And of course, Gunner knew he had to get the story, and Britton did too. So they switched places, and Sherman Nickens took the picture of Gunner coming out of the water with the bag. And Rich, you still here? Rich Riebling is here. I believe that's your father-in-law, is that right? Rich Riebling's father-in-law, Jack Gunner, banner photographer, coming out of the pond with the goods.
You know, there was a part in the trial where when Britton was being cross-examined, and he talked about the fact that I think they had trouble finding the pond, and he called a source to get better directions on where it was. And so David Pack, I think, was cross-examining Britton and wanted to know, well, who was the source? And Britton refused, and then Joe Binkley basically defended Britton. No lawyer from the banner, just Joe Binkley defending Britton. And the judge was saying, well, he doesn't have to tell you because of the Shield law, and Pack, who had been the Attorney General, reminded the judge that the Shield law had been found unconstitutional or something like that. And he still went ahead and said, no, he didn't have to answer it.
You know, Ed, I don't think any lawyer today would do something like that. And the danger of giving a confession before you have all the discovery, you can say things that might be refuted by other evidence. And while at the time it was a brilliant tactic for a variety of reasons, that's something we probably wouldn't be doing today.
Well, one of which would be the rules of professional responsibility, and particularly in federal court, you could never do it because they have rules about lawyers talking to the media. Right. And, you know, you can hardly say squat to a reporter if you're in federal court, and I think the state judges have gotten much more strict on it. Last thing, we're almost done, and by the way, we're back on schedule, so, you know, way to go, Big Ed. I made a gratuitous remark a few minutes ago about drinking, lawyers and drinking, and you know, we've had an interesting variety of opinions on that today because apparently Judge Morton felt like Beebles was more confident with alcohol than he might have been without, like the lawyer in Knoxville. But seriously, and it is a serious subject, what do you guys say about the role of, you know, the bar, the TLAP program, and so on today? And are we any better off, or are we still just about as bad as we were in '73?
My experience, we're far better off. We are a brother and sister's keeper. We have that obligation to each other and to ourselves to do that. Too many crimes happen because people allow other folks to do that and think we're self-regulating. And I've seen what you talk about, the toddies at the afternoon, everybody going off to the bars and things, and that has changed for the better. We still have a long way to go, but I think we're doing
I do think, on reflection, that the DUI law of 1982, where they put in the 48 hours and some other very strict rules that we still have today, changed the lawyer Christmas party big time. The lawyer Christmas party used to be a time for lawyers to go from Union Street to, you know, James Robertson Parkway and the Court Square building and all these places and just drink into the night. And, you know, probably helped the budgets of a lot of law firms, but the Christmas parties really started to die down after the strict DUI law came into effect 36 years ago, and that's probably a good thing. How are we on schedule, Mr. Landquist? All right, now, a couple of things you have to remember. You've got your yellow sheet, fill that out, turn it in for your CLE credit, dual credit, and let's give one more big thank you to all our participants who put on the program today.
Ed, what happens
He's alive and well in Nashville, and he attends the Cornerstone Church up here on, yes.
Rye whiskey, rye whiskey, rye whiskey, I cry. If I can't get rye whiskey, Lord, I surely will die. I'll go up some holler, put a bar under my steel. I'll make you 1 gallon for a $10 bill. Rye whiskey, rye whiskey, rye whiskey, I cry. If I can't get rye whiskey, Lord, I surely will die. Rye whiskey when I'm thirsty, homebrew when I'm dry. Pretty women when I'm lonesome, and heaven when I die. Rye whiskey, rye whiskey, rye whiskey, I crave. I'll drink this rye whiskey till I'm laid in my grave. They say whiskey will kill you if you drink nothing but rye. But an old man past 90 and he's still mighty spry.